Good day, Miss. I'm Samuel Lau, and today I'm tasked with presenting an important legal assessment concerning the state of Mandela, potential accession to the International Covenant on Civil and Political Rights, which will be referred as ICCPR later on, and particularly its first optional protocol. As the Prime Minister legal advisor, I will also discuss the feasibility of entering a reservation to Article 1 of this protocol. So first, what is first optional protocol and what is ICCPR? The ICCPR, adopted by the United Nations General Assembly in 1966, is a cornerstone internationally treaty aimed at assuring the protection of civil and political rights globally. To enhance the enforcement of these rights, the first optional protocol was introduced, allowing individuals to submit complaints to the HRC regarding violation of the rights protected under the ICCPR. The first optional protocol is a supplementary treaty that establishes a mechanism for individual complaints. Article 1 of the protocol grants the Human Rights Committee the competence to receive and consider communication from individuals claiming to be victims of rights violation under the ICCPR. This mechanism is crucial for ensuring that individuals have an avenue for redress at the international level when domestic remedies have been exhausted or are even unavailable. So by acceding to the first optional protocol, Mandela will subject itself to greater international scrutiny regarding its human rights practices. The Human Rights Committee will have the authority to review the individual complaints and make recommendations, which could lead to increased pressure on Mandela to align its domestic laws and practices with ICCPR standards. An accession to the protocol may necessitate a comprehensive review and amendment of Mandela's domestic legal framework to ensure compatibility with ICCPR obligations. This will likely involve strengthening legal protection for civil and political rights, enhancing judicial independence, and ensuring effective remedies for rights violations. The protocol also provides an additional layer of protection for individuals in Mandela. By allowing individuals to bring complaints to the HRC, Mandela would be recognizing the importance of international oversight in safeguarding human rights. This could empower citizens and foster a culture of accountability and respect for human rights. Joining the first optional protocol could bolster Mandela's international reputation as a state committed to human rights. However, it could also expose the state to criticism and obligations if the HRC finds Mandela in violation of ICCPR provisions. The decision to join the protocol must therefore balance these considerations. And moving on, let's look at some journal articles and their scholar perspective on this protocol. And first, we can look at the book by Sarah Joseph, The ICCPR Cases, Materials, and Commentary. She highlights the protocol's roles in providing a crucial avenue for redress and accountability. And similarly, Christoph Hans and Franz Wern argue that the individual complaint mechanism enhances the effectiveness of the ICCPR by enabling direct participation of individuals in the international human rights system. And additionally, in a journal article by Natalia Squiffing, Jamaica withdraws the right of individual petition under ICCPR. She discusses the implication of Jamaica withdrawal from the optional protocol. She emphasizes that the individual petition system is one of the most effective enforcement mechanisms within the international human rights legal framework, despite challenges in state compliance. She also notes that Jamaica withdrawal removed an important avenue of redress for individuals facing human rights violations, highlighting the significance of maintaining this mechanism for protecting individual rights. And moving on to the second issue, reservation to Article 1 of the first optional protocol. So first, let us understand what is reservation. A reservation is a unilateral statement made by the state when signing, ratifying, accepting, approving, or acceding to a treaty, whereby the state aims to exclude or modify the legal effect of certain provisions of the treaty in their application to the state. Reservations allow states to consent to be bound by a treaty while not agreeing to specific provisions. The Vienna Convention on the Law of Treaties, VCLT, provides that legal framework for reservations. Article 19 of the VCLT stipulates that a state may formulate a reservation unless the reservation is prohibited by the treaty. The treaty provides that only specified reservation may be made or the reservation is incompatible with the object and purpose of the treaty. Article 1 of the first optional protocol establishes the HRC competence to receive and consider individual communications. The core objective of the protocol is to provide an effective mechanism for individuals to seek redress for human rights violations. So a reservation to Article 1 will effectively negate the primary mechanism for individuals. So a reservation to Article 1 will effectively negate the primary mechanism for individual complaints, undermining the very purpose of the first optional protocol. The Human Rights Committee has consistently held that reservation undermining the right of individual petition are not permissible. And for this, we can look at a similar case, which are discussed by Thomas James Phillips in the journal article, The Invalidity of Turkey's Reservation to Article 27 of the ICCPR. We can see that reservations incompatible with the object and purpose of a treaty are generally deemed invalid. He also elaborates on Turkey's restrictive interpretation of minority rights, which was challenged based on its incompatibility with the broader goals of the ICCPR. This analysis could directly inform Mandela's consideration of reservation to the first optional protocol, emphasizing that such reservation may not withstand international legal scrutiny if they fundamentally alter the treaty's intended protections. Just as Turkey's reservation aimed to limit its obligation under the ICCPR to specific groups, which was arguably against the treaty's purpose to provide broad protections, a similar reservation by Mandela to Article 1 of the first optional protocol could be seen as undermining the right to individual competition. The article by Phillips can be cited to demonstrate how international law views reservations that restrict fundamental human rights guarantees, potentially leading to their invalidation. In practical consideration, including an analysis based on Phillips' discussion, will help illustrate the risk associated with such reservation, reinforcing that Mandela could face not only legal challenges, but also international criticism for attempting to dilute its obligation under the first optional protocol. This might prompt Mandela fully comply with the protocol's provision without reservations, aligning with international human rights standards and enhancing its international standing. So, in light of the above analysis, it is recommended that Mandela accede to the first optional protocol to the ICCPR without entering a reservation to Article 1. The protocol provides a crucial mechanism for individuals to seek redress for human rights violations and enhances Mandela's commitment to upholding civil and political rights. Entering a reservation to Article 1 will undermine the protocol's effectiveness and contravene international legal principles. Therefore, it is in Mandela's best interest to fully embrace the obligations under the first optional protocol to strengthen its human rights framework and international standing. And that should conclude my part, and that should be all from me. Thank you very much for your attention. for your hearing. Thank you.